Yes. Prosecutor chair.
Okay, thank you. Can you call docket and do a formal arraignment?
If you haven't filed a waiver, we will do a formal arraignment.
Okay.
Yes.
Okay.
Yeah.
Thank you.
Oh, pretty.
Good morning.
Not on yours. I can't figure out the book on yours, so.
Yeah, it's just another example of what was 4212 now, 42A being poorly written.
Yes. So when you change the number, that doesn't improve the
That's
content.
right. I think that's all they must have got too. Busy. But too good. Yeah.
Steve, I'm your girl. We don't care what.
Copy. And we were. I think he has.
I don't know. In one place it says he can't. But then,
It's found a case that said.
yeah,
For specific.
yes, absolutely. Yeah, I figured he's going to, but
Yeah, I'm not, wouldn't be surprised because. How well I got it.
yeah.
Not bad.
Good morning. I'm
How are
Shayna
you?
Fallhaber.
Shayna Alfredo Hernandez.
Good to see you.
Pleasure to meet you.
Are you one of our prosecutors?
I am. Yes, ma'am.
I figured by the placement.
Yeah. Yeah. What were you
Awesome.
here on today?
I have arraignment on Cedric Thompson.
Okay.
I do not have a plea offer, and I emailed yesterday with,
Okay.
I believe her name was Stephanie.
Yes.
And she was supposed to bring me a flash drive with a phone dump that I was gonna trade her for this one.
I did not hear about that this morning. Generally, I have counsel go by our office to
Okay.
do that.
Okay, I can do that when I
So,
leave here.
okay.
Not a problem.
I will confirm with her that all that's been set up here. Check with her to make sure that all that's been set up for you, so you won't have to wait.
Appreciate that.
Uh-huh.
I know you're gonna be handling the docket this morning,
Myself and Chris,
because I believe the
Hartwell.
case might be assigned to Mr. Curry.
either Chris or I will be handling.
Okay.
More likely than not.
Oh, okay.
Yeah. What was your client's name again?
Cedric Thompson.
Okay.
A bunch of cases this week.
Not a ton, since it's pretty small rock.
Yeah.
Oh.
Yeah.
Yeah, so the only thing I did find was a last.
So do you have discovery then already?
I have to agree
I
with
think
shared
that's the only thing
portal.
else.
Okay, yeah.
And when I was looking at it yesterday,
Yeah.
I was like, there's a phone dump. I don't have it. So
Ah,
I emailed
got it.
her.
Okay.
Like,
Yeah.
please have that.
And I think, is this the first arraignment or second
First.
arraignment? And that's probably why you would have had an offer anyway.
Okay.
So it's not till we see your face and know that you're gonna be
And
entering, and from here on out, I guess we'll make a note and on our docket, and we can certainly send out an offer to you via email.
Perfect.
Yeah,
Thanks.
okay. Right. So we'll just let the court know that we're working on providing you a complete copy of discovery.
Okay.
And you should get the phone dump today, and probably set it out. I think he's sending out what, mid-April, late April?
Yeah,
Okay.
oh, yeah, we should, because March, we really don't have, we have two settings on the entire month, so.
Yeah.
That's fine by me. He's on bond and again,
Yeah.
I still have a cell phone dump. to
Have
pick
you
up.
grab a,
Yeah, so yeah, we're looking at probably mid-April.
Okay. Thank you. So he does call.
he will call everything up.
Okay.
Uh-huh. Yeah, you have a thumb drive? Okay. Apparently, somebody was gonna make it available. So I just sent her a thing.
Oh, I thought I could- Damn.
What? Oh. You see, oh, probably saw it already.
All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Clifton Gross. Pascal Waters. Lisa Peace. Durante Calhoun. Dylan Holzhauser. Dylan Wade Holzhauser.
Judge, I was in communication with him this morning. He said he was gonna be here. He may just be running a little bit late.
We'll recall this case. Quavian Jackson. Stephen Richardson. Andrea Whitaker. Alyssa Rodriguez. And Cedric Thompson. All right, thank you. All right, do we have any counsel that's ready? Mr. Thompson, come on up. Go ahead and put that road back up. All right, this is cause number CR 25-19, State of Texas versus Cedric Earl Thompson for arraignment today. Are we ready for arraignment?
Yes, Your Honor.
Go ahead.
Thank you, Your Honor. Shayna Fallhaber on behalf of Cedric Thompson. At this point, we would waive formal arraignment, enter a plea of not guilty for purposes of arraignment.
All right, the court finding that Mr. Thompson has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, and we will set this for pretrial today.
Your Honor, I still have some discovery that's outstanding that I intend to pick up today.
Well, that's okay. So we're just going to set it for pretrial. So I'm going to set it for over 30 days. You could pick all that up and follow your pretrial motions.
Yes,
You have your calendar available?
I do.
Some dates I have available in April would be April 10th, April 8th, April 10th, 15th or 17th.
April 15th, please.
All right, court sets Mr. Thompson then for pretrial hearing April 15th. So Ms. Fallhaber, if you'll just pick up your discovery, have all that reviewed, and then file any pretrial motions. Really, the ones I'm worried about are the ones that are going to be contested, motions to quash, motions to suppress, anything of that nature. File that 7 days prior to that 15th date, and then we can take the matter up then.
Yes, Judge. And could you please let me know what time on April 15th?
9 o'clock. And if you do file a motion to suppress or a motion to quash, it will not be heard that day. We will schedule it that day, but that's just a deadline for you to file those motions if you need them. If you find that you don't need to file any of those motions, then on that date, I will set you for a docket call announcement that will give you time to continue negotiating with the state and making a decision whether you want to reach a resolution by plea or by trial.
Yes, Your Honor.
All right, and then do you have the notice of appearance form?
I do.
Okay, once Mr. Thompson signs that and gets the yellow copy, then you're free to go.
Thank you so much.
You're welcome.
I just want to take a picture of it for myself real quick. Here's your copy. No. I bet I can get up on one too. Thank you very much. May we be excused?
Yes, ma'am.
Thank you. I'll talk to you out in the hall.
Great. Are you and Ms. Peace ready?
Just we're ready, like, start, hit maybe this. Bird is gonna be involved.
That's correct, Your Honor.
But otherwise.
Okay. Pascal Waters. All right, Mr. Waters, good morning. This is cause number CR 25-20, State of Texas versus Pascal Todd Waters. Mr. Waters, you have been indicted with the third-degree felony offense of evading arrest or detention with a vehicle. Can you hear me?
No, sir.
All right. Can you hear me if I speak up like this?
All right, can I move
No.
closer?
No, just stay there. You can't hear me if I speak up right here?
Yeah, I can hear if you speak up, sir.
Okay. Mr. Waters, you've been indicted with the third-degree felony offense of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years in prison, up to a maximum 10 years in prison, and a fine not to exceed $10,000 if you were to be convicted and sentenced. Do you intend to hire an attorney to represent yourself?
I'm supposed to have Richard Smith.
What does that mean you were supposed to have him? Does that mean that you hired him?
Yes, sir.
You did hire him?
Yes, sir.
Okay, and so you've met with him and you've paid him money?
Excuse me?
You've met with Mr. Schmidt and you've paid him money?
Yes.
Okay, so I guess have a seat then, and I'll have Mr. Schmidt come in here. He hasn't indicated to me that you've been his client.
All right.
Go ask him. Good morning, Mr. Gross.
Good morning.
This is cause number CR 20-80, State of Texas versus Clifton Nasir Gross. Mr. Gross, I see today that you're asking for the court to extend your probationary period. You're currently set to expire on March 23rd of this year. It appears that you're asking the court to extend you for an additional 2 years. Is that correct?
Yes, sir.
And why do we need to extend your probationary period?
I wasn't in a position to pay the fines off in the correct amount of time. So that's the only thing I have left. I've completed everything else, and that extension will give me enough time to complete that.
Okay. And do you understand, Mr. Gross, that during the extension, you will be required to pay probation fees and your analysis fees during that extension period?
Yes, sir.
Okay. And Mr. Gross, you're asking the court to extend your probation period today because that's what you want to do. Is that correct?
Yes, sir.
And you believe that doing so would help you comply with your conditions?
Yes, sir.
Okay. All right, Mr. Gross, the court will approve the extension of your probationary period for 2 years. That will have your new expiration date be March 22nd of 2027. Okay, so I've signed this amendment. Come over here and see the probation officers and they'll get you a copy.
Yes, sir.
And then you'll be free to go.
Awesome.
Okay,
Thank you, sir.
come on over. You can come on over this way, Mr.
Okay.
Gross.
Get Chris to move over. He's like, no, I'm good.
Right, court calls number CR 22-389, State of Texas versus Lisa Ann Pease. Today, we are set for sentencing in this matter. The court heard the evidence in a bench trial on January 24th, 2025 on the charge of prohibited substance or item in a correctional facility, a third-degree felony. After hearing the evidence and arguments of counsel, the court found Ms. Pease not guilty of prohibited substance or item in a correctional facility. However, the court did find her guilty of a lesser included charge of possession of a controlled substance, a state jail felony. And at this time, I believe that, or at that time, rather, the court had ordered the Van Zandt County Community Supervision and Corrections Department to conduct a pre-sentence investigation report into this matter to assist the court in sentencing. Ms. Curry, on behalf of the DA's office, did you receive that report from the probation department?
Yes, Your Honor.
And Mr. Green, did you as well?
Yes, Your Honor.
At this time, are there any objections to the report or any requests for additions, deletions, or modifications from the state,
No, Judge.
from the defense?
Yes, Judge. On page 2 of the pre-sentence report, under paragraph B, or the criminal history part, paragraph B, there's an indication that Ms. Pease has been convicted 3 times of a felony, and there is no indication that that's accurate. There are some arrests that are noted in the later on in the pre-sentence report that was from records that came from Texas Department of Public Safety, that there was some arrests, but no indication that she's ever been convicted of a felony. Visiting with Mr. Hartwell, I believe he has searched their records and it's indicated that they have not been able to find any convictions for felonies.
Thank you, Mr. Green. The court has reviewed the defendant's criminal history that was attached to the pre-sentence investigation report. And this court, in reviewing the pre-sentence investigation report, also did not find any convictions in the defendant's criminal history for felony offenses. Does the state have any different information?
No, Judge.
All right, so the state agrees that Ms. Pease has not been convicted of felony 3 times as provided by the probation department.
Yes, Your Honor.
Any other additions, modifications, or deletions, Mr. Green?
No, Your Honor.
All right, then the court will take notice that Ms. Pease has not been convicted as a felon in the state of Texas. All right, Ms. Curry, at this time, we would enter into the sentencing phase of this matter. Would you like any type of opening statement? Do you want to call any witnesses or offer any evidence?
No, Judge, we'll have argument only.
Okay, Mr. Green, would you like to call any, first of all, would you like to have an opening?
No, Judge.
Okay, would you like to call any witnesses or offer any evidence?
No, Judge, we would just argue what the appropriate sentence is based on the pre-sentence report.
Okay, do you defer to the defense at this time? Do you want
Yes.
to reserve? Okay, Ms. Curry, having reserved her argument to final argument, Mr. Green, go ahead.
Your Honor, we believe that pursuant to 42A.551 of the Texas Code of Criminal Procedure, that this is a case in which Ms. Pease is that provides that Ms. Pease is the sentence should be probation. It states that except for some otherwise stated sections, that she was convicted under 481.115B of the Texas Health and Safety Code, that she should be punished under, the judge shall suspend the imposition of the sentence and place the defendant on community supervision. So we believe that that section is the appropriate section that provides that the court shall place her on community supervision in this case, because, she has not been previously convicted of a felony. And she was not convicted under 1235 of the Texas Penal Code. So we had asked the court to place, Ms. Peace on a period of, community supervision not to exceed 5 years. We believe that, based on, the amount of substance that she had in this case, that a lower end of the 5 years, the 2 to 5 years would be appropriate, somewhere around 2 or 3 years community supervision with the standard conditions of probation for someone that's been placed on a probation for a substance abuse, substance controlled substance offense. And that I know that probably, at issue with probably the court and with the district attorney is, whether she should, attend substance abuse, treatment, and perhaps substance abuse treatment inpatient. We just remind the court that prior to, trial, that Ms. Peace did submit, to substance abuse inpatient treatment in the state of Florida on her own and at her own cost, and believe that, also based on the substance abuse evaluation that she took as part of the pre-sentence report, that it indicated she has a low probability of substance abuse disorder. Believe that outpatient treatment was appropriate at this time. So we asked the court, for those, that should be placed on probation with those standard conditions of probation.
Thank you, Mr. Green. Ms. Curry?
Thank you, Your Honor. Just briefly, Judge, I cannot disagree with Mr. Green's reading of the statute. However, I do disagree somewhat with his view of the facts as he's presented them to the court. This is a defendant, Judge, who has had a long history of drug abuse, a long history of illegal activity in this community, particularly in and around her residence. She admitted to this court that she needed substance abuse treatment when she went to Florida prior to trial and entered a residential treatment program. By doing that, she admitted that she needed it. And in fact, she asked the court to put off the trial so that she could continue getting the treatment she needed. By her own admissions to this court, she has told us all that she needs inpatient substance treatment. As this court well knows, we don't have the funds to pay for that, but we do have safety at our disposal. And I believe that her conduct, both in relationship to the offense, her conduct in telling the court that she needs inpatient treatment, and keeping in mind, Judge, the fact that, yes, it's been 2 years since this offense, but in that whole 2 years, she was not drug tested a single time. So we can, by her conduct, conclude that she continued using drugs after her arrest because she didn't go to treatment for more than 2 years after her arrest. And therefore, Your Honor, if we're going to put her on probation, we want two things. We want her to be successful, number one, and we want the community to be protected from people who use, distribute, drive while under the influence of drugs. And the best way to do that, Your Honor, the best way to ensure both of those is to send her to safety.
Thank you, Ms. Curry. All right, the court's going to consider the arguments. I will recess this case for a few moments. Let me take up some other issues, and then we'll come back for the court's decision.
Thank you, Judge.
Mr. Schmidt, are you ready on anyone? Are you ready, Mr. Schmidt? Stephen Richardson. Mr. Richardson, come forward, please, sir. This is cause numbers 2024-219 and CR 25-12, State versus Stephen Ray Richardson. I believe that we were set for pretrial on the harassment with previous conviction, but we're set for arraignment today on the burglary of habitation, second-degree felony. Are you ready to proceed on that, Mr. Schmidt?
Yes, Judge, I've received a copy of the indictment. His name's correct. We waived formal reading and our plea of not guilty. We'd ask for a pretrial setting on that one and carry the misdemeanor pretrial as well.
All right, the court does enter Mr. Richardson's plea of not guilty into the record. Court will also find that he's waived the formal requirements of arraignment. Court sets each case for pretrial hearing. Mr. Schmidt, would you like April 8th or April 15th?
April 15th would be great.
Okay, court sets each case for pretrial April 15th. Once Mr. Richardson gets his notice of appearance, he's free to go.
Yeah, you can go.
Anyone else, Mr. Schmidt?
Alyssa Rodriguez.
Mr. Rodriguez? All right, this is cause number CR 18-175, State of Texas versus Alyssa Michelle Rodriguez. We're set on the motion to adjudicate today. Go ahead, Mr. Schmidt.
That's correct, Judge. And I was appointed this month to represent Ms. Rodriguez. I'm gonna ask the court for some additional time, see if we can't work it out.
All right, court will set Ms. Rodriguez for hearing on March 27th. If Ms. Rodriguez does not have an agreement by that date, then we will do a contested hearing on the 27th.
Yes, sir. Hey.
Mr. Schmidt, before you leave, you and Mr. Waters, is there an attorney-client relationship between you and Mr.
There
Waters?
is not one established yet, Judge, but I have been in contact with Mr. Waters and I expect there to be one.
Okay. I'm gonna bring him up then and I'll reset him. He had indicated to me that he had hired you and that he had paid you.
I've been doing business with his wife.
Okay. Mr. Waters? All right, Mr. Waters, what I'm gonna do, I'm gonna reset your case that's for arraignment today. I'm gonna reset it until April 8th and give you time to meet with Mr. Schmidt if you wanna hire him or someone else. But I need you to have an attorney hired before April 8th so that you can come back to court with an attorney to represent you on this felony case, okay?
All right, thank you, sir.
I need you to sign this form here and then you're free to go. Jermaine, are you ready on anyone?
Yes, Judge.
Who would you like to call first?
Mr. Calhoun?
Durante Calhoun, CR 24-300. Mr. Calhoun is set for pretrial today.
Yes, Judge. Mr. Calhoun had some videos that were not working on the portal. I was made aware that the DA's office had prepared those and I picked those up a little bit earlier this month, but have not had an opportunity to speak with Mr. Calhoun. We requested additional pretrial to go over discovery in his case.
Any objections from Steve?
No.
All right, then the court will reset pretrial for Mr. Calhoun. You available on April 10th?
Yes, Judge.
All right, court sets Mr. Calhoun for pretrial April 10th at 9 a.m. Once he gets his notice of appearance, he's free to go.
Thank you, Judge. Judge, next ready on Mr. Holhauser.
Dylan Wade, Holzhauser, CR 24, 268, 269, 270, 271, and 272. Believe that we're set for pretrial on all cases.
Yes, Judge, we are prepared to move forward on a plea, prepared to set this for a plea. For this case, the one thing that we're missing is itemized restitution. We've requested that in this case, but other than that, we've worked out the terms of the agreement. We'd request, be set for a plea on the next sitting.
And Your Honor, we'd ask that also be set out, if possible, to that April date, just to give us time. It's just the complexity of the case and everything. Would like to give our victim a chance to have a fair opportunity to get that itemized list, and for Mr. Manning to have a full opportunity to review it.
All right, court sets Mr. Holzhauser for plea April 10th. Will that be a morning plea or an afternoon plea?
Morning, day, Judge.
At 9 a.m.
Yes, Judge.
Thank you, Your Honor.
You're welcome, sir. Who's next, Mr. Manning?
Judge, next ready on Mr. Jaquavian Jackson.
Mr. Jackson, this is cause number CR 21-361, State versus Jaquavian Antron Jackson. Motion to adjudicate. Go ahead, Mr.
Judge, Mr. Jackson, as you remember, is on compliance to get the payments to both the probation department and the court's collections department. Judge, he made a $500 payment last time, is anticipating making a $400 payment when he receives his check for the end of this month. Additionally, Judge, he was drug tested last time and did test clean. We'd ask to be set out additional month so he can continue making payments as he has.
All right, so what I'll do is we'll give Mr. Jackson an opportunity to drug test again today. If he's negative as well again, then what we'll do is we'll reset to March 27th.
Yes, Judge.
All right, so Mr. Jackson, have a seat in the hallway. Mr. West will be out there. Need to do the drug test, and then you'll wait for further instructions from the court, okay?
Yes, sir.
Anything you want to-
Judge, I have Ms. Whitaker. I just got her paperwork, so I will go over that. We'll be ready for a plea shortly.
Okay, all right, then the court will stand in recess for about 20 minutes. It's about 20 till court will resume at 10 a.m. Back on record, clause number CR 21-361. Court had previously stated that the court would reset Mr. Jackson's case to March 27th. The court has had Mr. Jackson drug tested pursuant to the probation conditions. Any announcements on any changes to your previous announcements, Mr. Manning?
Yes, Judge. I'd like to change the compliance setting for 327. We've reached an agreement to resolve Mr. Jackson's case. That resolution will involve going to TDCJ for a period of 2 years. I would ask that he be allowed to turn himself in on March 27th at the 1:30 docket. Additionally, Judge, I have explained to Mr. Jackson the consequences if he fails to appear, both by incurring additional charges and being exposed to the full range of punishment for a second-degree felony, which in this case is 2 years up to 20 years.
All right, Mr. Jackson, I'm going to grant your request. I'm going to allow you to plea on March 27th at 1:30. You're to submit yourself to the Van Zandt County Justice Center. Failure to do so would not be beneficial for your case and could also result in new charges by the state of Texas in the form of bail jumping. So we'll see you back on March 27th at 1:30. Any questions?
No, it's not.
All right.
Judge, may I approach?
Yes.
Yes, Judge.
Ms. Whitaker, this is cause number CR 24-245, CR 24-246, State of Texas versus Andrea Lauren Whitaker, also cause number CR 24-244. All right, Ms. Whitaker, if you'll raise your right hand, I'm going to place you under oath. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sure, Honor.
All right, you can lower your hand. Your name is Andrea Lauren Whitaker, correct?
Correct.
And Ms. Whitaker, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Are you currently on medication or under treatment for that?
Yes, sir.
Do you feel like you have a rational understanding of what's going on in court today?
Yes, sir.
In this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Do you have any questions about your plea agreement before we go forward?
No, sir.
All right, Mr. Manning, do you believe Ms. Whitaker to be competent today? And if so, have you explained to her the rights that she has with regards to both of these cases?
I have, Judge, and I do believe she is competent today.
And do you believe that she is entering into this agreement intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Ms. Whitaker, in cause number CR 24-245, you were originally indicted with a second-degree felony offense of burglary of a habitation. Is that the correct indictment? Because this says that you're pleading to a Class A misdemeanor assault.
Yes, Your Honor. It was a burglary by way of assault.
Oh, it was pled burglary plus burglary with entry with intent to commit assault.
Yes, sir.
All right, so this is a lesser included?
Yes, sir.
Okay. All right, so Ms. Whitaker, I see that the plea agreement today is for you to plead to a lesser included offense of assault causes bodily injury of a family member, a Class A misdemeanor, which carries a range of punishment up to 365 days in the county jail and a fine up to $4,000. I see the plea agreement is that you would plead guilty to that lesser Class A misdemeanor crime in exchange for the state's agreement to recommend conviction of that offense and then you being placed on 2 years of community supervision and a fine of $500. Is that correct?
Judge, if I may, it's actually deferred.
Okay, I see it's down here. It says deferred, but up there, okay. So Let me restate that, Ms. Whitaker. So it appears that you would plead guilty to the lesser included offense of Class A misdemeanor assault causes bodily injury of a family member. The state would agree upon your plea to ask the court to defer a finding of guilt on that crime, meaning that the court would consider the evidence but would not convict you. Rather, you would be placed on 2 years community supervision along with an assessment of a $500 fine, court cost of $270, reimbursement fees of $540. In cause number CR 24246, in which you were charged by information with was she charged by information or indictment?
Judge, I believe they indicted this case.
Class A indictment?
And I'm sorry, Your Honor, I was double checking something. Are we still on the burglary or?
No, we're on 246.
246, I'll look up that one as well. Yes, Your Honor, that one was an indictment.
A Class A misdemeanor indictment?
Yes, sir.
All right, Ms. Whitaker, you were indicted with a Class A misdemeanor offense of resisting arrest, search, or transport, which also carries the same range of punishment up to a maximum 365 days in the county jail and up to a $4,000 fine. I see that the plea agreement in that case, that upon your plea of guilty, the state's recommending to the court that you be convicted of that offense with a sentence assessed at 91 days in the county jail, in which you would receive 91 days credit for time served. In addition, you would be fined $500, $270 in court costs, and $20 in reimbursement fees. And then lastly, in cause number CR 24246, in which you were I'm sorry, 244, in which you were charged with assault of a police officer or judge, a second-degree felony. The state of Texas has filed a motion to dismiss that case. All right, so Ms. Whitaker, do you understand the plea agreements that I've read to you?
Yes, Your Honor.
All right, understanding all of that, I would ask you, how do you plead to the Class A misdemeanor offense of assault causes bodily injury of a family member? How do you plead?
Guilty.
How do you plead to resisting arrest, search, or transport?
Guilty.
Are you pleading guilty to each one of those crimes because you are in fact guilty of committing each crime?
Yes.
Okay.
Your Honor.
And Ms. Whitaker, has anybody threatened you, forced you, or pressured you to plead guilty to either one of these crimes?
Yes, sir.
All right, the court will accept the defendant's plea of guilt in each case respectively. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
All right, the stipulation in each case is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, on the burglary of a habitation, state is in compliance with victim services. Victim impact statement was mailed out in October and was not returned. So we have not been successful in making contact, but we have made attempts. In the resisting arrest, that's directly connected to the assault of a peace officer, and law enforcement is supportive of that plea.
All right, thank you, Mr. Hartwell. Anything further from the defense?
Rest on close, Judge.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of each offense in cause number CR 24-245 on the charge of Class A misdemeanor assault causes bodily injury of a family member. The court will follow the plea agreement. The court defers a finding of guilt, places Ms. Whitaker on 2 years community supervision, orders her to pay a $500 fine, court costs of $270, and reimbursement fees of $540. In cause number CR 24-246, on the charge of Class A misdemeanor resisting arrest, search, or transport, the court, having reviewed the evidence, follows the plea agreement today and convicts Andrea Lauren Whitaker of that offense, assesses her punishment at 91 days confinement in the county jail, awards her 91 days credit for time already served, orders her to pay a $500 fine, court cost of $270, and reimbursement fees of $20. The court, having received the motion to dismiss in cause number CR 24-244, the court grants that motion, and that case is dismissed. Ms. Whitaker, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'll have you come up here to be fingerprinted with Deputy Martinez. Here's your other one.
Yes.
Judge, I believe that concludes my morning docket. May I be excused?
Yeah, thank you, Mr. Mayor. Appreciate your patience. Ms. Peace, come on up. You can go ahead and have a seat.
And Your Honor, can we approach on this real quick?
Yes. All right, we are back on record, cause number CR 22-389, State of Texas versus Lisa Ann Peace. Officer Mature, we're currently on the record on Ms. Peace's case. The court had requested that your department conduct a urinalysis test of Ms. Peace. Has that been conducted?
Yes.
And, well, let me place you under oath. If you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right. And so you did follow the court's order and you conducted a urinalysis exam of Ms. Peace for the presence of controlled substances. Is that correct?
Yes.
And what were the results of that test?
The instant test was positive for methamphetamine and THC.
Okay. And did you have any discussions with Ms. Peace about the results of that test?
I did. She did deny use, so we're gonna send it to the lab.
Okay. Court will note that and order you to send that to the lab for confirmation. Any questions from the state?
Nothing from the state, Your Honor. Thank you.
Any questions, Mr. Green?
None, Your Honor.
All right, thank you, Officer Jim. Mr. Hartwell, did you have a request from the state with regards to anything, including a test by the department?
Yes, Your Honor. State would request that sentencing be continued until those results come back. I believe it would be an important part of the court's rendering sentence today. Additionally, Your Honor, if the court were to grant that continuance, state would ask that Ms. Peace's bond be held insufficient at this time.
Thank you, Mr. Hartwell. Anything further, Mr. Green?
Judge, we just asked the court to continue with sentencing this morning.
Okay. All right, court does deny the state's request to continue sentencing for the confirmation of the instantaneous drug test administered by the pretrial release department. All right, in this case, the court finds that Ms. Peace, having been convicted of the state jail felony offense, possession of a controlled substance in penalty group 1 less than 1 gram. Court also finding that Ms. Peace has not been convicted of any felony in the state of Texas or any other state. The court finds that the law requires this court to place Ms. Peace on community supervision. And the court hereby orders Ms. Peace, court hereby sentences her to 2 years confinement in the Texas Department of Criminal Justice State Jail Division. The court, under the law, is required to suspend that sentence. The court does suspend that sentence today and places Ms. Peace on 5 years community supervision. The court assesses a $2,500 fine. As condition of community supervision, the court orders Ms. Peace to attend the substance abuse felony punishment facility and complete the treatment therein. And the court assesses court costs in the amount of $290 and restitution in the amount of $180 for the testing of the controlled substance in this matter. Ms. Peace, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. You're going to be taken into custody today so that you can await a bed at the Safe P facility.
Judges, court entertained her being on intensive supervision, awaiting a bed for safety rather than having to sit in jail waiting for a long period of time.
Unfortunately, the policy of this court is for them to be taken into custody to await the Safe P bed, because should Ms. Peace show up at the Van Zandt County Justice Center under any type of influence, that would prolong the availability of the bed at Safe P. So this way the court can ensure that she will be clean when her bed is available at Safe P.
Okay.
And I can check on it. It's usually about a week and a half, 2 weeks before the bed becomes available at Safe P. The court has made this decision based on the evidence in this case. Ms. Peace having checked herself into the rehab during pretrial prior to the hearing, and then also Ms. Peace's testing positive today for substances. The court understands that she denies that. However, that's the court's decision.
And if the urinalysis test were to be confirmed, when when it is confirmed, if it shows negative, the court entertain, the request to, allow her to be out while she waits.
I don't think I would, Mr. Green, because that would preempt the court's policy of ensuring that she's clean when the bed is available.
So as I understand, it's the court's policy for everyone that goes to safety.
That's correct. I don't allow anyone to check themselves. We don't request that the bed be ordered, and then when it become available, that we order them into custody at that time. I've done that in years past, and it's been unsuccessful each time.
Okay.
So in order to ensure that it's as efficient as possible, she'll go into custody, she'll remain there, the bed will be ordered. As soon as it's available, they will be able to take custody of her right then, so she can begin her treatment.
And did I understand the court said that it's an RA check to see what the waiting period was?
Usually it's around, we ask Officer Ventura, it's usually around 2 weeks if it's not special needs.
Okay,
And I don't believe that this piece would be special needs.
I don't believe so.
Is she on any type of medication or anything that you believe would be narcotic or anything?
I don't think it's narcotic.
If it's typical blood pressure or something of that nature, or arthritis, 2 to 3 weeks. Is that, and that's for regular safety? 2 to 3 weeks.
Okay, I understand you.
Deputy Martinez, if you'll go ahead and take this piece into custody at this time. Mr. Hartwell, I assume that you're working on the judgment for the court.
Right now, Your Honor, thank you.
Do you have phones or anything you want to give to him?
We'll have to have Ms. Peace thumb printed, but we'll take it out to the jail. But once the judgment is produced, then make sure that Mr. Green gets to see a copy of it. And then the court will sign that and I'll have her fingerprint.
Yes, sir.
That does conclude the court's morning docket. Court will stand in recess until 1:30.